Welcome to today's lecture in our year-long lecture series on race and regulation. This lecture series is organized by the Penn Program on Regulation. I'm Kerry Colanisi, the director of the Penn Program on Regulation and a professor at the University of Pennsylvania Law School. This lecture series on race and regulation focuses on the most important task for every society, ensuring equal justice and dignity and respect to all people. Today's lecture will focus on administrative law's racial blind spot, how civil rights and administrative law in the United States have diverged over the last 50 years. Our speaker is Daniel E. Ho, the William Benjamin Scott and Luna M. Scott Professor of Law at Stanford Law School. At Stanford, he is also a professor of political science, a senior fellow at the Stanford Institute for Economic Policy Research, associate director of the Stanford Institute for Human-Centered Artificial Intelligence, and director of the Regulation, Evaluation, and Governance Lab, or Reg Lab. Professor Ho has produced some of the most important and sophisticated empirical legal research focused on administrative law and regulatory policy. With the Reg Lab, his work has developed a number of high demonstration projects on data science and its uses in public policy and public administration through partnerships with a range of administrative agencies at all levels of government. He received his JD from Yale, his PhD in political science from Harvard, and clerked for Judge Williams on the U.S. Court of Appeals for the District of Columbia Circuit. His lecture today is co-sponsored by the Legal Studies and Business Ethics Department of the Wharton School here at the University of Pennsylvania, as well as our partner for the entire series, the University of Pennsylvania Law School's Office on Equity and Inclusion. At the conclusion of Professor Ho's lecture, we will have an opportunity for questions from the audience. To submit a question, simply click on the Q&A button at the bottom of your Zoom screen. I will then be able to see your questions, and we'll try to ask as many of them as time permits. Now, without any further delay, it is my distinct honor and privilege to turn the screen and the microphone over to Professor Ho to speak on administrative law's blind spot. Professor Ho?
Thanks so much, Kerry, for that really generous introduction, and thank you to you for organizing this lecture series into the Pennsylvania Law School. I've learned a tremendous amount from this lecture series, and we'll actually try to connect some of the threads back, particularly to Professor Oleti Johnson's really terrific lecture from a few weeks ago. What I'll talk about today is based on joint work with Cristina Ceballos, who's a wonderful JD PhD student here at Stanford, and my colleague David Freeman Engstrom, who's also on the law school here. And want to thank particularly Nicole Allicock, who was the editor at the Law Journal, who really shepherded this piece through the process. To start off with, I want to just paint what we started off with in this project as what some might consider to be the curious status quo in administrative law. Look no further than the recent oral argument around the Centers for Medicare and Medicaid Services vaccine rule for healthcare workers, where the argument offered by Missouri on brief and in oral argument was that HHS, quote, ignored the mandate's disparate impact on rural hospitals, but the APA denies HHS the right to be willfully blind to reality. Yet in oral argument or in the arbitrary and capricious review on the pages of the US reports, racial disparities, which have been so prominent in the pandemic, were nowhere mentioned, despite the fact that a reasonable weighing as a policy matter would have to think about not just the distributive implications on rural populations, but on minority populations as well. And that is really the kind of puzzle that we dealt with in this piece. It is black letter administrative law that the reviewing court shall hold unlawful and set aside agency action findings and conclusions found to be arbitrary and capricious. And claims for disparate effects are entertained seriously across the administrative law canon. To give you some examples, when the Forest Service issues a particular rule for park visitors, differential effects between kayakers and jet boaters are considered in an arbitrary and capricious type challenge. We've had a Supreme Court case that contemplated seriously the differential effects on types of business owners, small broadcasters or large broadcasters. And similarly, when the Navy has a kind of rule about the use of sonar, administrative law takes seriously claims for differential effects on small dolphin pods versus large dolphin pods. But when it comes to differential effects across race, administrative law is, in a sense, curiously silent. So one example comes from a claim by a public interest group challenging the use of methyl bromide as pesticides, and the case did not recognize the claim for differential effects between Latinx school children and white school children that were differentially impacted in California. Nor in a case called Garcia versus Vilsack, where there was a claim about the failure to investigate discrimination and the kind of differential effects were minority farmers' claims recognized under administrative law. And the project really tries to grapple with how is it that we have arrived at this curious status quo. We have, in a sense, a stark contrast between the scholarship that has highlighted the pretty significant potential role of the state and regulation in racial stratification. Look no further than this lecture series where Jessica Traunstein discussed the role of land use regulations. There's amazing work by others like Joy Milligan that have documented the role of education policy in generating racial stratification. And so what we do in this piece is to try to actually go back and understand the origins of what we call this form of disparate limbo. And that really at core requires examining the interaction of the Civil Rights Act of 1964 and administrative law. Under the Civil Rights Act of 1964, Title VI allows for or protects individuals from discrimination in federal programs or activities. Section 601 says, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in any program or activity receiving federal financial assistance. Section 602 is the agency mechanism to potentially cut off federal funds when there's a violation of 601 by a recipient of federal financial assistance. And then 603 is the provision in the Civil Rights Act, Title VI, that somewhat confusingly spells out what the judicial review provision should be, noting that any agency action made pursuant to 602 shall be subject to such judicial review as may otherwise be provided by law. And in the case of action that isn't otherwise subject to judicial review, terminating or refusing to grant or to continue financial assistance, any person aggrieved may obtain judicial review of such action in accordance with the APA. Then the other less taught provision under the APA is Section 704 that says agency action for which there is no other adequate remedy in a court is subject to judicial review. And so we went back and looked at the sort of legislative history. And when it comes to Section 603, which would be the provision that could provide a vehicle by which to actually seek judicial review, there are sort of two potential theories of what APA review might achieve. The first is as purely a shield for individuals who have agency funding cut off. So perhaps Section 603 is only introduced for those individuals worried about having their funding cut off because of a finding of discrimination. But the other is the use of the APA as a kind of sword when an agency fails to cut off funding, perhaps in the presence of a finding of discrimination. And the statute itself and the legislative history is quite deeply ambiguous on the conception of 603. But one sort of a bit of legislative history that is worth noting in this context is that two fierce opponents of the Civil Rights Act, Representatives Poff and Kramer, themselves in a section of a kind of report called Cut Off the Funds, themselves actually noted that judicial review authorized by the Civil Rights Act is to the Administrative Procedure Act. And they themselves noted that it is available for those who bring charges of discrimination and who are aggrieved by the negative ruling of the administrative agency. No matter how frivolous the charge may be, the complainant may demand, and the circuit courts must entertain petitions for judicial review. It is obvious that the passage of this legislation would clutter the docket of the circuit court with an unmanageable caseload. What, of course, to infer from this kind of a minority position is somewhat less clear, and the relationship between the APA and the Civil Rights Act hence gets spelled out through adjudication in the appellate courts thereafter. And to sketch out the way in which the DC Circuit in particularly fleshes this out is that as a backdrop, we have the 1979 Cannon case that is widely seen to provide for a private cause of action for disparate impact. Under that backdrop, when the DC Circuit first heard a case that involved the Office of Revenue Sharing and claims of discrimination in block grants to the states, when the challenge was made against the Office of Revenue Sharing, the DC Circuit in an en banc decision relied particularly on APA section 704, stating that there was an alternative adequate remedy, and that was under Cannon to pursue case-by-case private actions against the recipients of block grants. It's worth noting that in that en banc decision, Judge Spotswood Robinson, who was a civil rights attorney, argued Brown versus Board of Education in front of the Supreme Court and was the dean of Howard Law School before assuming the seat in the DC Circuit, himself already presaged what is one of the concerns articulated in our piece, which is that the result is that the agency is, quote, wholly insulated from judicial review. It may close its eyes to allegations of discrimination. That is, what is the vehicle by which one could actually get at agency abdication to actually discharge its obligations under Title VI? What we then get is another en banc decision in the DC Circuit, the women's equity case, which Joy Milligan's work also has done some really terrific documenting of the case history here, which involved federally funded educational institutions. And invoked the similar kind of move to infer that because of Cannon and the implied private cause of action, there is an alternative adequate remedy. Therefore, the claim cannot be heard under the APA. But what's particularly curious is that women's equity looms large in this particular space when individual litigants raise both discrimination and APA claims, even after the Supreme Court reverses course and in Alexander versus Sandoval finds that there is no private cause of action for disparate impact claims, reversing what had been the kind of consensus under Cannon since 1979. And nonetheless, women's equity continues to get cited in this case law as a way to channel discrimination claims away from garden variety APA suits, leading to what we document in the paper and call a form of disparate limbo. Civil rights plaintiffs sit in disparate limbo, unable to make out the stringent intent showings, but simultaneously barred from mounting claims invoking the APA's baseline guarantees of non-arbitrariness. So that's the kind of what we put forth in the piece as to the origins of disparate limbo. Let me turn briefly to some of the implications from this account. First, we think that it would be wise for federal courts to cabin the scope of women's equity in really two ways. The first is that APA Section 704 should allow for APA claims for differential effects that can no longer be brought post-Sandoval under Title VI. And second, the particular concern animating the en banc DC Circuit in women's equity really stemmed from the colossal nature of the case. The worry was about federal supervision of subfederal actors and bringing in all sorts of different kinds of schools. Women's equity should not apply to cases like Garcia versus Vilsack, where there's a direct challenge to the federal agency and where this overseeing the overseer concern is not really at issue. Second, we do think it's worth actually taking seriously this analysis of what adequacy means under APA Section 704. One case that was not cited in the women's equity decision is the Bowen against Massachusetts Supreme Court case that really interrogated the adequacy of the alternative claim much more seriously. Another canon of administrative law, Abbott Labs, of course, painted 704 as being a provision that should really be interpreted to broaden access to the courts, not to narrow access to the courts. Third, we do think that some of the stark contrasts between the kinds of differential effects that are recognized by the courts under the APA, like those relating to the National Environmental Policy Act or the Regulatory Flexibility Act in terms of different kinds of small business interests. Those are actually the kinds of moves that could be brought into administrative law, essentially to mandate similar kinds of disparate impact assessments that would, as a result, lead for more rigorous assessment of these kinds of claims for differential effects. One example that Professor Ola T. Johnson has written about in her work that is an exemplar along those lines comes from the Obama administration, where the city of Oakland had proposed building an airport connector from the BART, the high-speed rail system, to the Oakland airport. It was a $500 million infrastructure project, but the Federal Transit Administration initiated a civil rights review because the concern was that the routing of this airport connector, would have gone through the heavily African-American neighborhood in the East Oakland community, and the fare structure would have fundamentally changed to have actually made it a much less affordable option to get to the airport. And also said that there was insufficient participation by local neighborhood groups in this particular proceeding. And under that sort of mandated equity analysis, ultimately the $70 million of federal funds that were used for this project were diverted towards other means. The other intervention that I'll just highlight that I think is a very affirmative step forward is Executive Order 13985, Biden's Racial Justice Executive Order, which says that, quote, each agency must assess whether its programs and policies perpetuate systemic barriers for people of color. Many federal data sets are not disaggregated by race, ethnicity, gender, disability, income, veteran status, or other key demographic variables. This executive order, if implemented faithfully, would really lead to much more of a kind of equity directive in federal regulatory agencies. That said, the language right here points to one of the really substantial epistemic challenges here, which is that under the Privacy Act of 1974, there are many agencies that don't actually have the ability to link their records easily with information about protected attributes. that runs into particular challenges when we think about what is on the horizon in terms of algorithmic bias. Carrie has done some leading work on this, and with David Engstrom, Kathy Sharkey, and Tino Cuellar, we wrote a report about the use of algorithmic decision tools by federal regulatory agencies. And one kind of emerging mantra from those coming from within the machine learning community is that there is no fairness without awareness. It is very difficult to understand what potential impacts and might be and how to mitigate a potential bias without understanding these disparities. And that was the subject of some extent of discussion in the GAO's Controller General Forum, where the GAO was trying to come up with audit standards for algorithmic decision tools, and remains a really big challenge if you simply don't have access to protected attributes to understand these dimensions. So how do we do better? Well, let me connect this to Professor Johnson's lecture from a few weeks ago, where she talked brilliantly about some of the social disparities of disease. And I think a lot of the future work that remains to be done is really to make these kinds of disparities more visible. So let me give you a kind of one example from COVID response. This was done by the state of in Georgia, where a lot of the times, just as with federal regulatory agencies, race and ethnicity information was missing in COVID surveillance data. And they used some imputation techniques, really based on name and address information of where patients resided, and showed that basically once you add those imputations, the ratio of the absolute racial and ethnic disparity increased 1.3 and 1.6-fold for classified Black and Hispanic persons. Our team at the Reg Lab has done some work with Santa Clara County's Public Health Department. And if you look at the 1997 OMB categories for race, if anything, it looks like Asian Americans are faring the best in terms of most measures of COVID outcomes, case rates, positivity rates, and vaccination rates. But as many of you know, one of the big points of contention within the Asian American community has been to actually disaggregate and come up with better measurement, since the category of Asian Americans is an omnibus category. And it turns out when you do that, case rates actually look significantly worse, for instance, for Vietnamese Americans in Santa Clara County than if you're simply aggregating across a large omnibus category of Asian Americans. Another kind of similar solution is really to leverage administrative data. I think there's some really interesting efforts happening right now on the federal side to make that easier. Here's one audit that our team did of another use of data early on in the pandemic, where a fairly wide range of agencies were using data from mobile phones. This particular data set had 47 million cell phones by a company that advertised itself as being, quote, the source of truth about physical places. And of course, they had no information about protected attributes. And what we ended up doing is to actually merge individual location information with a voter turnout information at precise polling places, merged those with these data, and basically showed that the coverage declined as the voting population was older in a particular precinct. And so the very system that was used early on to monitor the effectiveness of social distancing may have been leaving out the very group that was most vulnerable, particularly early on in the pandemic to COVID-19. And of course, once you've uncovered those kinds of blind spots, that enables you to actually reduce these disparities by understanding the sources. And so the last example I'll give you relating in a sense to Alexander versus Sandoval, which was about language barriers. It was about whether a driver's license exam should be administered in other languages. And one of the real concerns by Santa Clara County's Public Health Department was that its contact tracing initiative, which within a matter of weeks was stood up to be 1,000 contact tracers, wasn't particularly effective with communities that spoke English as a second language. Contact tracing is one of these really challenging interactions where you're engaging people at a particularly difficult moment and then trying to get them to share information that can be seen as quite sensitive with you. Unfortunately, with the 300 or so labs reporting into the county, there was no systematic information on language needs. And so what we did in this project is we merged the incoming lab reports with administrative and census data to essentially predict language needs of incoming patients, and then matched those incoming cases with contact tracers that were bilingual, Spanish speakers in particular. And what we showed through that in a randomized controlled trial was that it reduced processing time by about 14 hours and improved the willingness to interview in this particular subpopulation. So I do think there is a lot that we can do to uncover these kinds of blind spots. And maybe before we open it up to Q&A, let me leave with kind of the broadest conjecture, and it is admittedly very much a conjecture of the piece, which is what this story of disparate limbo might have to say about administrative law and the project of administrative law more broadly. And the question that we ask in the piece is whether the kind of strengthening of hard look review, which happened contemporaneously to the erasure of race within administrative law doctrine, may actually have been critical to the construction of modern administrative law doctrine. As Peter Strauss really nicely puts it, we teach the case of Overton Park without ever really acknowledging in most case books the kind of historical context of these forms of highway construction. The park was segregated for much of the run-up of the plan for this highway construction, some 200 miles away under another urban renewal project in Nashville. The freeway that was proposed to be constructed would literally have separated two historically Black colleges and universities from the African American community. And so it's a natural question to ask, counterfactually, what would we have gotten from a seminal case on hard look review if the question about the impact of the feasible or prudent alternative had actually posed the question about its impact or its differential impact on minority communities? And it's not implausible to think that at least Overton Park and perhaps other forms of hard look review, had they been required to actually wrestle with these really challenging issues, might have actually evolved somewhat differently than the standard account that we tell today. With that, I will stop sharing my slides, and Carrie, I'm looking forward to discussing this with you.
Great. Well, thank you so much. Let me first encourage members of the audience, if you have questions, please fill out the Q&A portion of the Zoom screen, and I will turn to those. Dan, this is terrific. And I think, if all one has to do is look at the standard administrative law casebooks, and you put a few images of them up earlier in your presentation, and ask, how many of those cases come from the area of civil rights and how many come from the environment, labor law, telecommunications. And I think that reinforces the impact that you've been describing of this administrative law blind spot. I want to pick up on your last comment in your conclusion and invite you to engage in even further imagination, or just plain conjecture, as you say, or speculation about how do you think the world today might look had the courts not, interpreted 704 to in such a way to exclude these additional civil rights claims under the Administrative Procedure Act. And I invite you, to think about, when I ask how the world would be different, you can think about it any way you like, I suppose, but could be in terms of overall racial equity in society. How much do you think this has made a difference in terms of maybe the prospects of litigating successfully to challenge racial injustices, or maybe like I started off saying about our case books, maybe it would have changed the kinds of cases that our students read?
Yeah, it's a great question, and it's a tough one in the sense that it is a kind of broad and pretty wide-ranging one, and I guess I have both a kind of a positive answer and a somewhat more negative answer. So the more positive answer is that if we were to speculate and imagine that women's equity had been more cabined in its application and its use of 704 to toss out claims of disparate impact, a kind of more affirmative vision might be that in something like the CMS vaccine mandate case, rather than solely wrestling with the disparate impact on rural communities, we would, as a policy matter, also have to think about the really serious disparate impact that the pandemic has had on minority communities. That appears, to be sure, on the pages of the Federal Register in the initial CMS notice, but is absent really in the briefing and the Supreme Court's rather short passage on the arbitrary and capricious claim. So to put it differently, if a case like State Farm stands for the proposition that it is problematic for an agency to entirely fail to consider an important aspect of the problem, every lecture that has been part of the series has pointed out, in a sense, how important a dimension race has been in the regulatory state. And so the affirmative vision would be to have more serious sort of reckoning with that when we're really weighing and trading off these different aspects. The somewhat more skeptical answer that I have to your question to sort of about how the world might be different today, it goes in a sense to the broader question of the role of judges and constraints in the judicial construction of administrative law doctrine. That is, if it is the case that hard look review would look very different today if the 704 move had not been made to excise questions of race from the domain of administrative law, judicial review might also look quite different. So that's sort of why we end with the Overton Park example. And so that's a really hard counterfactual to really wrestle with, but it is possible that judicial review would simply have looked different had there not been this excising of questions of differential effects by race.
So one of the members of the audience asks a clarifying question that I think might be helpful to follow on this. And by the way, invite all members of the audience to type in further questions in the Q&A function on Zoom. But the member of the audience asks, am I understanding your argument that the APA then would serve as a way to fill the gap created by the Sandoval decision, where an administrative agency's investigation failed to reach a finding of discrimination? If so, then you're saying the agency would be the named defendant in the APA litigation, right? And I just thought I'd pose that and make sure that if there are others in the audience also, we could clarify the argument.
Yes, that is, I think that is the crux of it. That is, even, I think there's still an argument one can make that under the canon world, just as Judge Spotswood Robinson felt, the DC Circuit had it wrong, that these claims should still be cognizable, but certainly post Sandoval, the argument is that when you have claims for differential effects by subgroups, just as in a garden variety APA suit, you would consider the differential effects on small businesses versus large businesses. You should consider those, because the 704 move simply is not available to you anymore, because there is no alternative adequate remedy in the way that was assumed under the women's equity decision.
Mm-hmm. So in a sense, what is 704 says you can't proceed under the APA if there's an adequate remedy elsewhere. And the argument would be that post Sandoval, there's no adequate remedy for the kind of disparate effects consideration. And so since there's no adequate remedy anymore under the civil rights statute, you can now proceed under the APA.
Exactly.
Be a little change of direction or reverse course.
Exactly. Now, the one thing I will add to that is that we do not suggest that you would import wholesale a Title VI regime into the APA. It would, of course, be subject to the way that the APA deals with these kinds of differential effects claims. So it would be a different set of doctrines, and particularly all of the APA deference doctrines would kick in. So it would not be an identical kind of analysis as you would get in a disparate impact case, where if you show that a facially neutral policy has had differential effects, then in say a Title VII case, the employer can come back and make a showing of business necessity, and then the employee would have to have the burden to show the existence of a non-discriminatory alternative. That would not be what would be imported in the APA context. It's the failure to consider an alternative that can be deemed to be arbitrary and capricious, and the failure to consider an important dimension of a particular problem. But that would, of course, be tempered with all the standard deference doctrines that are part and parcel of the administrative law canon.
Right. So excellent. That's very helpful. And I suppose one could take Biden's executive order, by the way, perhaps in a direction that tells the Justice Department, should you, now that you've read this brilliant paper by Professor Ho and his co-authors, shouldn't you be making this argument in court? Isn't it? And I wondered, that the article itself, by the way, has a really terrific political economy analysis and theory about why this divergence probably happened, and I think it's certainly a highly plausible and persuasive political economy analysis. But it also seems like that same kind of political economy would apply just as well today. And I wondered, how much we really could expect the courts to go forward, or this Supreme Court ultimately to go forward and shift the course here on how 704 is interpreted. And one of the members of the audience here writes, maybe I'm being too cynical, but I don't see any chance we can make progress on changing rules with an eye to racial equity with the current Supreme Court. Are you more optimistic, Dan? And if so, how do we get to a more optimistic ending?
Yeah, in the article we describe it as in a sense the hollow hope critique due to Gerald Rosenberg of what is the role of courts when it comes to social change. And I hear that a little bit, I think, in the political economy kind of critique to spell it out, which we've already alluded to in the tail end of the talk, is that if there was if the modern project of administrative law was to strengthen these kinds of review doctrines, maybe it did so precisely because race was omitted from the equation. And it would have been a much riskier proposition for courts to have built the project quite in the same way had race been part of that equation. But of course, those kinds of constraints are ones that are going to bind in the present moment as well. So I think it's Joy Milligan who, in her work, shows how the Public Housing Administration, for instance, maintained a segregation because it was fearful that its funds were going to be cut off by Congress. And so, what are the concerns about a kind of congressional reversal if you started to make this kind of a move? And I guess one perspective on this is that it is going to be a limited amount that courts can do. Look to the recent reflection, for instance, by Professor Nico Bowie on the role of the Supreme Court, and that's really why, in many ways, what we point to are more sort of legislative or executive interventions to remedy the current state. I don't think this will be solved simply by cabining the reach of women's equity. But if you borrow a playbook from the playbook of NEPA or the Regulatory Flexibility Act, those are the kinds of provisions that have strengthened under the APA the scrutiny of the kind of differential effects on small businesses or on environmental interests. And so those would be the kinds of interventions that could actually strengthen the lens under the APA with respect to race as well.
Well, I think you definitely your proposals at the end about identifying sources of bias and addressing it, becoming more aware of it, raise the question then of how do you get agencies to do that, right? And so it could be, as you say, some executive initiative. One of the questions from the audience: what about could legislation be the answer? But then another question that comes in from the audience is, well, would that legislation, would that be constitutional? Because we have a court that for many years has been trying to discourage, in some sense, the consideration of race by government agencies. And your solution is, and legislation that would back up that solution would say, agencies, go take race into account. Do we have a constitutional collision here if Congress were to require this kind of analysis?
Yeah, it's a really profound question. Maybe let me say a little bit first about ongoing executive action, because I do think that EO 13985 is a really important step. There's now a kind of task force that is required really to help implement this at each agency, to understand whether there are disparities that exist in federal programs. And I think that's a really important first step, though a very challenging one, given that not all agencies will actually collect direct information about race and ethnicity. And I think there's a lot of very important work to be done of how to still sort of implement that. I think there's some really important initiatives on even on the data side. If you think about initiatives like the National Secure Data Service or the National Research Cloud, which are really trying to, in a way that's consistent with the Privacy Act of 1974, facilitate administrative record linkage to have better evidence-based policy. One of the really important outcomes from that is that if we make it easier to actually, for research purposes, link to the census records, we can gain a much better understanding for that set of agencies that doesn't have protected attribute information to understand what existing disparities might be. But the question that was asked really, in a sense, goes to the question that's foreshadowed in the Ricci versus DiStefano case, where this is the New Haven firefighters case, where the Supreme Court is considering whether sort of getting rid of the test results because of the fear of disparate impact itself violates disparate treatment. And you have Justice Scalia really in some very strong language hinting at the fact that disparate impact doctrine itself is just at war with disparate treatment. That's kind of one of the big questions looming on the horizon. I think there's a more limited way to interpret something like EO 13985, first to understand the dimensions of racial disparities and not necessarily figuring out yet how to act upon that, because you can often identify, once you understand those mechanisms, ways in which to reduce those disparities. That doesn't necessarily mean actually taking race directly into account when engaging in an agency action. And that, I think, is an important way forward for a wide range of federal programs.
Doesn't that make the agency vulnerable to a hard look challenge, right? I mean, especially if the courts were to adopt a fix to the kind of blind spot that you have identified, which, by the way, I'm not sure it came out in your lecture remarks, but it was Judge Ruth Bader Ginsburg who really authored at the DC Circuit level, the prevailing women's equity decision that you say, that you've cited and say is so widely cited for this disparate limbo that has been created. But anyway, doesn't this sort of make an agency just susceptible to say, okay, you've now uncovered this, but you haven't provided any reasoning for how you or why you went ahead in the face of this evidence?
Yeah,
I mean, in other words, would hard look review actually force agencies to grapple with what racial justice really means and how to overcome or reconcile some disparate effects with other kinds of social objectives, maybe that they're involved in with their policies?
Yes. in a nutshell. Yeah. Right. And it is this, that is in a sense why we start off with this peculiar status quo. In a sense, nearly every lecture in this series is pointed to the role of the regulatory state in racial stratification, yet it doesn't show up when we're reviewing agency action under a kind of hard look review challenge. And that's a really peculiar sort of status quo that we will take really seriously the claims by rural hospitals versus urban hospitals, or small broadcasters versus large broadcasters. It doesn't necessarily mean that the agency will change its ultimate disposition, but it's worth it to recognize and understand, just as the Supreme Court did in FCC versus Fox, that it's true that this may have this may be harder, this fleeting expletives policy might be harder to comply with for small broadcasters, but there are some reasonable ways of going about it. And the kind of consultation with the Small Business Administration is meant to air out potential mechanisms by which to actually craft a rule that both acknowledges and in some ways accommodates those interests. And why don't we do that when it comes to the question of race?
Is part of the answer, and this picking up on a question from the audience, is part of the answer that differentiating between, let's say, large and small broadcasters fits within the relevant regulatory statute. And if the regulatory statute doesn't mention some kind of discrimination on the basis of race, would that by itself suggest to the court, or should it suggest to the court that that's not the kind of distinction or disparate impact that is contemplated under hard look review in the context of, let's say, a telecommunications regulation?
Yeah, that's a really important point. You could try to distinguish the CMS case or FCC versus Fox or some of the NEPA cases by saying, well, no. Under the kind of HHS statute, there's a specific provision that talks about the interests of rural hospitals, or NEPA in particular requires you to pay particular attention to environmental interests, or the Regulatory Flexibility Act really requires you to think about small businesses. And if that's one's positive account as to why administrative law currently takes those interests so seriously, whereas it doesn't take claims of differential effects along race and ethnicity seriously, in a sense, therein lies the potential intervention, right? Why not have a Regulatory Flexibility Act with respect to racial justice, or a NEPA for sort of statements that account for the kind of distributive effects of regulations. And then that would be the kind of action that would fold this in to the purview of administrative law consideration.
So there's a comment and question that came in from the audience, and I'm going to just read it. Isn't the problem really that the Supreme Court and members of the public too do not believe that race has been or continues to create disadvantage, or that government has policies have created this disadvantage on the basis of race? One example is the recent wave of laws this questioner poses, purporting to limit how schools address issues of race and its role in U.S. history, the so-called debate over critical race theory in public schools. In the gender area, Chief Justice Roberts has seemed shocked that discrimination continues because, after all, it is illegal. So the failure to recognize that a problem exists, this questioner poses, is the real barrier to dealing with the issues. Would you agree with that?
Yeah, I think that is we are living in this kind of moment of racial reckoning, and it is absolutely the case that people hold quite divergent perspectives on the role of race, though I think a lot of people are also reflecting on their understanding of the role of race. And this lecture series is in a sense a really important intervention to try to understand that when it comes to the intersection of race and the administrative state. So in some sense, I would argue that actually the very blind spot that we're sort of documenting here is part of that reason. That is, when we're talking about the role of the USDA when it comes to farming communities. The USDA, which by some was referred to as, quote, the last plantation. We had, over the course of the 20th century, a dramatic shrinking of the population of the fraction of farmers that are African American, and part of the role was actually the way in which USDA administered farm benefits with a very decentralized decision-making structure, decentralizing loan decisions down to the county committee, that made it really quite amenable to forms of discrimination in individual loan decisions. And I think the question, in a sense, is right, that part of the raison d'etre of all of these discussions is in a way to heighten awareness of the role of the regulatory state in these kinds of dimensions.
And one maybe the final question here about what might be today thought of as a pillar of the regulatory state, and that is benefit cost analysis and review by OIRA. And the questioner asks whether this benefit cost analysis process at OIRA suffers the same blind spot, and what kind of solutions might there be to that? And as you know, as you certainly know, Dan, and others members of the audience may know, but there is a circular A4 guidelines that accompany the executive order that governs regulatory review through OIRA, the Office of Information and Regulatory Affairs in the White House. And one may well see under Biden's executive order some revision to the guidance A4 coming perhaps in the months ahead. And one question might be, for you, Dan, if you were rewriting that in light of the analysis you've presented here, how might it look?
Yeah, it's a great question. There are these antecedents under the sort of OMB guidance and the way OIRA carries out its cost-benefit analysis to actually conduct an analysis of distributional consequences. So I think it was under the 2003 guidance, agencies were instructed to consider the distributional effects of their rules. And that lends itself quite naturally to trying to understand the impact of a regulation across demographic groups. And that would be, I think, an important move forward that would be consistent with the Biden racial justice executive order. I do think there's also very interesting work along those lines to be done. The way in which we somewhat crudely in a lot of cost-benefit analyses just tabulate dollars. And if you started to think of, from there's been really great work, for instance, in public finance to think about what would an optimal tax theory look like that actually took fairness into account. And you can think about that from the perspective of the marginal dollar being, having more utilities if you're on the lower income part of the spectrum, or having preferences with respect to an equitable distribution. And that would be the kind of formal analysis that could start to be imported into cost-benefit analysis in the same way that we try to look at sort of net welfare effects, actually be more transparent about the kind of distributive effects, and potentially wrap that all in a larger welfare analysis of like the optimal sort of distribution of regulations impact. So I think that would be a very interesting move forward. It would of course help to have an OIRA administrator in place to move that forward.
That will probably be a necessary condition, I would think. But I think you're right. I mean, the net welfare effects, which is what the benefit analysis, cost analysis is really trying to estimate, is an aggregate effect, right? And discrimination, disparate treatment, disparate impact is all about disaggregation. It's no accident that Our lecturer today is a political scientist, which political science is all about who gets what, when, where, and how, right? It's all about distribution in a way. It's what politics is, but the economic analysis has historically focused on just the aggregate effects in the Kaldor-Hicks efficiency framework. We are unfortunately out of our time today, and so my apologies to those whose questions we did not get to, but my many thanks to Professor Ho for a tremendous article and an exceptional lecture today, and I hope everyone in the audience shares my sense that this has been very illuminating, and the kinds of recommendations that you're making and the diagnosis that you've offered, as challenging as it may be to overcome, seems to be pointing in the right direction, and asking the hard questions is often the most important task that scholars can do. So with that, I want to thank everybody for attending, and thank you again, Dan, for being with us today and giving us a extraordinary final lecture in our year-long lecture series on race and regulation.
Thank you, Carrie, for all your work in making this happen. It's been a pleasure to be able to participate.
Thank you all. Have a good evening.